what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? And you may begin when ready.
As philosopher William Blackstone proclaimed, habeas corpus is a high prerogative writ that should be only suspended during times of great crisis.
The Habeas Corpus Act of 1679 incorporated sentiments from English common law and the 39th clause of the Magna Carta. Establishing habeas corpus safeguards citizens from wrongful imprisonment, but not in times of national crisis. This writ of liberty can be found under Article 1, Section 9.
Federalist number 84, Alexander Hamilton states that the establishment of the writ of habeas corpus is perhaps a great security to liberty. Additionally, the inclusion of habeas corpus serves as a restraint on the executive's power, ensuring a more limited government.
For example, Thomas Jefferson was the first president to try to suspend the writ to combat the Burr conspiracy. This attempt was approved by the Senate, but ultimately rejected by the House of Representatives. The House's rejection of Jefferson's attempt ensured a check against executive jurisdiction over suspension and set a precedent of limited executive power over the writ.
The state of habeas corpus and who is privileged to receive it changes as society's values become more progressive. The Judiciary Act of 1789 restricted habeas corpus to prisoners in federal custody because at the time, direct appeals regarding federal criminal convictions were unavailable, as even combatants should be able to petition to see a day in court. In 1867, federal habeas corpus review was extended to state prisoners under the Habeas Corpus Act of 1867, expanding the writ to all imprisoned on American soil.
During the mid-20th century, the Warren Court greatly expanded the federal writ, largely due to the constitutionalizing of criminal procedure through the incorporation doctrine, affording state prisoners more opportunities to claim that their convictions were unconstitutional.
However, the 1996 Anti-Terrorism and Effective Death Penalty Act dramatically changed the granting of habeas as it limited availability for appeal in proceedings by federal prisoners. The 2004 Russell v. Bush case emerged with the new idea that federal courts have the jurisdiction to hear cases regarding foreign enemy combatants currently held in Guantanamo Bay, thus evolving habeas corpus to include non-citizens as well.
Some argue there is never a large enough circumstance for habeas corpus to be an unreasonable burden to the government. Even in the most extreme cases like terrorism, the U.S. must uphold habeas corpus.
However, in the case Hamdan versus Rumsfeld, the executive lawyers argued that during times of war, the executive has the power to declare people enemy combatants and restrict their right to a day in court in order to protect the country. But their argument failed to win them the case, as the Fifth Amendment guarantees them the right to due process. So Bush asked Congress to pass the Military Commissions Act of 2006, eliminating enemy combatant rights of those imprisoned in Guantanamo. But that act was ruled unconstitutional through Boumediene versus Bush, upholding that suspending habeas corpus, not during times of national crisis, and even in the case of foreign enemy combatants, is unconstitutional.
On the other hand, habeas corpus might pose a challenge to cases in which it is apparent that the suspect has committed the crime, but the evidence is weak. For example, the government prosecuted both Al Capone and O.J. Simpson for the more minimal and less sensational crimes, but failed to prosecute them both for murder. If the prosecution cannot prove a crime, then the suspect cannot be prosecuted, no matter how likely it is they committed it.
During the last few decades, federal habeas corpus law has undergone many fundamental transformations. Ergo, it has been essential for our government institutions to uphold habeas corpus principles established by English common law and by our founders to ultimately protect civil rights and uphold modern due process.
Perfect timing indeed. One of the most famous examples of this habeas corpus being suspended was Lincoln during the Civil War. So I wonder if you could talk a little bit about that. Could you evaluate Lincoln's suspension of habeas corpus, and do you think it was justified?
So it's really interesting how we see the executive branch suspend habeas corpus, whereas in the Constitution, we see that it's more the legislative branch ability under Article 1, Section 9. So ideally, it should have been the legislative branch, but during times of national crisis, sometimes the executive makes power moves and then the legislative branch follows up with approving them. Whether or not that's constitutionally sound is not necessarily as important as the fact that because he was able to suspend habeas corpus, he was able to make swift action during that time of national crisis.
All right.
Furthermore, in the Constitution, it never explicitly states who has the power to suspend the writ. It's not either the president or the Congress. And during the Civil War, President Lincoln decided to suspend the writ when Congress was not in session, which made one person who was suspended the habeas Merriman to say, "Mr. President, you can't do that." But then when Congress was in session, they said, "Sure, Mr. President, we can suspend him for you." So yes, it is a controversial power to have either the executive or the legislature. But of course, it was during a time of great crisis. Thus, I think it is justified.
Very good. I'm going to follow up a little bit on the evolutionary aspect of the writ. You sort of concluded that part with some of the recent rulings around foreign enemy combatants. So I'm interested in, I guess, primarily your opinion supported is, do you agree with the rulings in that regard as far as foreign enemy combatants having some right to a writ of habeas corpus? And is there any constitutional support for that in your view?
Hamdi v. Rumsfeld established that due to the Fifth Amendment of the Bill of Rights of the Constitution, enemy combatants are entitled to due process.
So it's really interesting how we value people that aren't necessarily citizens' rights versus our citizens' rights. In my opinion, it's absolutely necessary that the United States take steps to ensure that even if people aren't necessarily citizens, but they're facing our courts, that they get the same exact rights as our citizens. The great hypocrisy of America is we love to shout freedom and start wars in other countries trying to protect other people's rights. But in the case of Guantanamo Bay, we don't necessarily ensure them the same due process that we believe other countries should ensure them.
It is also important to note that one of the great instances in which habeas was suspended was in the Philippines, when Americans decided to help the Filipinos be liberated from the Spanish during the Spanish-American War. The Americans decided to not leave, and that's when insurrection ensued with the Filipinos, and that made Americans to suspend the habeas corpus of these Filipinos, and that is just not appropriate in that time, for it just definitely disregarded these foreigners with their rights.
When we start to take away the rights of people that aren't necessarily citizens, then we begin to blur the line of who is a citizen, who isn't, and who is an American. When we look at the Executive Order 9066, when we sent Japanese Americans into internment camps, we blur the lines of what is moral, what is immoral, and who deserves rights, because we absolutely cannot afford to take away the rights of citizens or even impede on the rights of non-citizens. It's necessary that everyone deserves the privilege of habeas corpus.
Thank you very much.
Okay, well, let's bring it to a very appropriate situation for those of us here in the Southwest. Apply your habeas corpus analysis to the recent influx of immigrants and those asylum seekers at our border. What's going on, and how does the habeas corpus work there?
So it's really interesting how the influx of immigrants, even after President Joe Biden was elected, how we interact with them, how we put them into immigrant camps, because people file for different things, such as asylum or such as a refugee. There's different legal court order proceedings. And sometimes we don't necessarily grant them habeas corpus or the ability to petition their case in front of a judge in a speedy trial, because there are so many people and the influx of immigrants has created court backlog. Us as America haven't necessarily done our job in ensuring everyone a fair trial and a fair chance to make their case of staying in America. And we've seen this happen with with Sheriff Joe Arpaio and how he treats those people in those refugee camps. He was prosecuted for it. And whether or not his pardon by Donald Trump was moral or not, we've seen that we haven't necessarily pulled up our end of the deal.
Article 1, Section 9 does not guarantee the writ of habeas corpus. Rather, it limits the government to uphold rule of law. Legislature has also passed many acts to reverse their actions within the Military Commission Act of 2006 that allowed for torture. Therefore, even if you are an immigrant, the Detainee Treatment Act that was passed, it ensues penalties for those who try to instill torture onto individuals to harm their human rights.
While my partner sees habeas corpus as a restriction upon government, habeas corpus can also be seen as a right. In the 90s, Brown v. Vasquez determined that habeas corpus is a fundamental instrument to safeguard individual freedoms against lawless state action. So in regards to the immigrants, they still have the right, and nowadays in what we consider habeas corpus, to a day in court.
Thank you.
A lot of what we've been talking about here gets to the tension of between individual rights and the collective good or public safety. Can you think of other examples, even outside of habeas corpus, other times in which civil liberties or constitutional rights have been set aside in the name of public safety? And do you think they were justified in doing so?
Yes, as my partner was stating, with President FDR's, with his executive order 9066, the internment camps happened and it suspended within Hawaii, the Habeas Corpus Act, yet the nation put aside many individual rights, as seen with Ex parte Endo, in which a woman was fighting for habeas to petition the court because she was in an internment camp, yet they offered her release because they did not offer other individuals release. And she ended up staying within that
Time.
camp 2 years.
Finish that thought, please. Yeah.
She ended up staying there 2 years. Yet that was because the president was trying to uphold the common good of the nation.
Thank you. Thank you all very much.
Yeah.
I thought you three ladies did a fantastic job. In particular, there was a lot of good evidence cited. We got Blackstone, the Magna Carta, Hamilton, Al Capone, and OJ were brought up, but I think they were brought up in a way that made your point very well. My other judges can correct me if I'm wrong, but I think this is the first time that habeas in the context of Jefferson and the Burr conspiracy was mentioned, which was I had forgotten about it, but it's an obvious thing. So I'm glad we heard from that. I think you guys were excellent on Lincoln and understanding all of the delicate nuances going on there, both between public safety, but also division of power between the different branches of government and the individual contingencies that were a part of that case. So I think that was all handled very deftly. And I would just say that what was also evident was your passion, and it's appropriate. These are issues that we should be passionate about, and these aren't just boring, esoteric kind of academic arguments, but they affect real people. And if that doesn't stir your emotions, then you're not paying attention. So clearly, you guys are paying attention, and I appreciated that.
Yeah, as judges, we like to get to go first so we don't end up kind of repeating our colleagues. But so I had written down, and one of the first things I had written, love the passion. So Mr. Murphy just mentioned that. The three of you present just an excellent case in that regard, your passion for it, your breadth of knowledge. I just had a number of things I was writing, everything from your reference to the instance in the Philippines, the dissection of the executive versus legislative branches and who's imposing it, the reference back to the Constitution. And I think it's one of the only times, you made Others have referenced Article 1, Section 9. Not many have said, well, it does this and it doesn't do that. And so I was very impressed by your positions there. So anyway, all three of you complimented one another nicely, and you gave additional critical thought to your teammates' answer, if you were adding to it or if you were starting. So most impressive by you three young women. Thanks.
Yeah, echoing my colleagues, fantastic job. Passion is clear. Ms. Willits must be busting right now because you've made her proud for sure. You get it, right? You understand this thing, right? It's some crazy sounding thing, but you understand its importance in our lives as American citizens. And I also like the fact that you're willing to critique. Sometimes civic education programs get sort of, oh, it should be patriotic exercises and you should learn to love America. It's like, I love America, but I'm also going to criticize it and critique it and question it when it's maybe not in line with our founding principles. And you did that. You called us out for hypocrisy. Good for you. Keep doing it. Because the only way we're going to get better is if we reflect honestly on who we are as a people, right? And so I'm really, really happy to see that. I was really intrigued, and I was going to follow up if we had more time. You kind of like, well, it might not have been constitutionally sound, but that was okay. It's like, oh, wow, let's get into that, because that would have been a fun conversation. Keep digging on those, because, you know, the Constitution's important for sure, and don't get me wrong, but it's a piece of paper, right? And it's a parchment barrier, as Mr. Franklin said. So it is there to be considered and to be looked at deeply. And when thinking about the 14th Amendment and the persons clause, everybody, and you reflected it, but anchor that argument in the 14th Amendment, and it just slams the door completely. I'm really impressed by your work. Good job.
Yeah, congratulations to and thanks to your teacher and each of you as well.
Thank you so much.